So, it's my pleasure to see you again in this lecture. I'm really happy that you decided to come for the third time. And I hope that you also feel good for seeing me, but I'm not gonna ask you how you feel. Let's forget that anyway. So, as you have realized, today it's really hot. It's almost summer. When I came to Japan, it was 2006, and people were asking me, what do you like in Japan? And I would tell them, I like the 4 seasons, especially spring and autumn, which do not exist now. You only have summer and winter. Maybe you have realized that. It was winter before until a week ago. Now it's summer. It will be summer until October perhaps. Then it will be winter. No spring, no autumn. Don't worry, I'm not gonna change my country. I will stay here. So, this is the third lecture. Please remember that everything we are doing in this lecture will be part of the final exams, of the true or false questions, of the gap filling question, etc. Let's start with a short revision. We were saying that in Japan, in the past, there was no civil code. And according to my opinion, maybe Japan did not need to have a civil code. I have a friend who is professor at Kansai University, and he is studying about primitive societies, so-called primitive, some societies in Eastern Asia where there is no law. And his result was that they are functioning perfectly because they have some other kinds of rules. So law is not the only choice. But as you remember, Japan was having some Tsusho Joyaku, trade, commerce treaties with foreign countries, which were not good for Japan. Japan wanted to negotiate about them, and the Western countries told Japan, no, if you need to negotiate, you need to be like us. So Japan was asking, what do you mean, like you? And the Western countries would say, you need to be modern. You need to have modern codes, hoten. So, as you remember, last week, I was saying that we are not sure what is modern and what is not modern. Perhaps not having laws is even more modern. It's the future, maybe. And I was telling you that this guy, I'm not sure if he is modern or not. So, last night I was watching TV, which is quite extraordinary. I usually do not watch TV, but they were having the figure skating or something. So I saw this. I saw the Japanese national team dancing PPAP, which means that I need to apologize to you. He's still modern. Okay? And maybe some old Japanese animation, which I have never watched, is still modern because the Russian skater Medvedeva, she was dancing dressed as Sailor Moon, which means that Sailor Moon is modern. So, you can see that we never know what is modern. Things change. However, Japan was told if you want to negotiate, you need to have a code. So last week I explained you the two basic steps Japan took. The first step was copy-paste. So Japan tried to translate the French civil code into Japanese and use it as Japanese civil code. This is not bad. Of course, copy and paste is bad for students. You should not do that. Why was it okay? Because as I told you, there was not so much time. Japan did not have so much time. Japan wanted to negotiate. And when you want to negotiate, you cannot wait for 5 or 10 years. So, copy and paste, it did not work. So they called Gustave Boissonade from France. He created a very good civil code, which, however, was of course of French influence. Of course, he is French, so the code he created was influenced by French law. It's quite interesting. I have a friend who is a professor in France, and he was telling me that, you know, Antonios, I've been to many countries, I have studied abroad, I can speak many languages, but I'm still French. So I asked him, what do you mean? He told me, you know, when I write a paper, it always has two parts, part A and part B. Part A has two subparts, part 1 and part 2, and each part has two sub-subparts. This is very French, because in France, this is the way they are taught to write academic papers. 2 parts, not 3, 2. So, I'm also Greek. I have lived in Japan for 11 years, but when I went to Rune, the western part of this campus, and I found the kebab, I was gonna cry. I was like, oh my God, kebab, my favorite food. In Greece, we like kebab, we love it. So you can see that we cannot change who we are. Anyway, now, it was really French. So in Tokyo University, they were doing an Anglo-American law way of teaching. As I told you, this has almost not changed even today. If you go to the Faculty of Law, Tokyo University, most of them are studying American law, the law professors, civil law. If you ask Kyoto University Faculty of Law professors, they will tell you we are studying German law. So Kyoto University Faculty of Law is said to be number 1 in Japan regarding German civil law. Okay? So, step number 2. You are French. We don't like your code. We are Japanese. So we will create our own code. 3 very young guys. The oldest was the same age with me. So you can see that they're quite young. Created a new civil code, which was the code prepared by Boissonade, with some changes influenced by German law. So, the civil code we have now in Japan is almost half French, half German. And also some other countries' influence, but basically half German, half French influence. Last week, before finishing the lecture, I asked myself a question. I asked, wait, you were saying that the Tokyo University professors are influenced by American law, but in the civil code, we don't have any strong American law influence. Why is that? The answer is here. This is a world map. If you are European, if you come from Europe, the world map is like this. Europe is in the center. If you're Japanese, Japan is in the center. So world maps change depending on which country you come from, you live in. I know it's not clear, but I cannot turn off these lights because it will be really dark. However, this shows which countries belong to the so-called civil law system, in Japanese, Dairiku Houkei, or to the common law system. In Japanese also common law, it's the same, they use the katakana, or hanrei hou. So, you cannot see clearly the colors, but North America, the so-called America, USA, belongs to common law, which means that, of course, I will not talk to you about details, but they have no civil code. Okay? In the common law countries, basically, they don't have codes, hoten. They have some laws, but it's not like Minpo Keiho, civil law, civil code, penal code, etc. So, the Tokyo University professors were influenced by America, but in the USA there is no code, basically, civil code. So they used the model of Germany, which is a civil law country, Dairiku Hou. Yes, Germany has a civil code. So they used the German civil code and the French civil code as basic models. I have many friends who are professors abroad. If you talk with professors from Europe, they will tell you, yes, I am a civil law professor. I am a penal law professor, Keiho. If you talk with Japanese professors, they will tell you, I am a civil law professor specialized in German law. I am a penal law professor specialized in French law. This is a big difference. Why is that? Because now you can understand, because Japanese law basically comes from abroad. So if you want to understand and develop Japanese law, you need to see what happens abroad. Whereas in Europe, basically, they don't care about what happens abroad, basically. Of course, they do research, but I don't have any friends from Germany who will tell you I am a foreign law specialist. Usually they are German law specialists, also comparing with other countries. So this is a basic difference. Any questions up to this point? Yes? Could you pass the microphone to her?
Hi. I'm sorry, but I don't really understand what.
No, you don't have to be sorry. Actually, you're getting some marks by asking a question, so you should be happy. Okay, so let's start with that again. You're very happy, and
I'm very happy.
And I would like to have your name too, please. Yes.
My name is Kelsey Hendricks.
Okay, could you spell that for me, please?
Kelsi.
Okay, thank you. Yes. Yes.
Okay, so my question is, what is essentially the difference between civil law and common law? Because I didn't really understand that.
Thank you. That's an excellent question. I omitted that part because it takes a bit time to explain that, but let's try to do that very shortly. In civil law countries, the center of law are actual laws, that means legislation. So you have, in most cases, a civil code, important, a penal code, Quixote, etc. So, if you do something bad, or if something bad happens to you, the first thing you do is you open these codes and you search. Is there any provision which applies? Whereas in common law countries, there are only a few laws. So the first thing you do is you try to find a decision, a court decision, a past court decision, which has decided on something similar. I was talking with a friend of mine who has lived in the United States for many years. And he told me that, you know, the reason why in the United States they don't basically have codes, but they have case law, so their law depends on court decisions, is that the United States of America is quite a young country compared to other countries, especially European countries. So they wanted to do everything from the beginning, which means that no laws. If there is a problem, we go to court, the court makes a decision, and that's law for future cases. Whereas in Europe, with long tradition, you have the laws, and if the laws are not enough, then the court might say something new. So shortly described, that's the main difference. Was that clear, or would you like? Thank you. Any other questions? So, yes. So Kelsey, is that correct? Kelsey. Okay. So Kelsey gave me the opportunity to mention something. I received some emails saying, I would like to raise my hand. I would like to have extra marks. I would like to get 100. But so many students, and they're really fast. I'm thinking, should I raise my hand? And they're like, oops. So, can't we do that in a different way? The answer is yes. The first way is asking questions. You will also receive, of course, marks. The second way is asking them questions during the break. In English, I will give you some marks. Okay? Not in Japanese. If you ask me in Japanese, it's really pleasant, but no marks. And the third way is, if you cannot raise your hand during the lecture, and if you cannot ask me questions during the break, you can send me emails in English, and we can arrange a meeting at my office. And if you ask me questions, or if you say something about the lecture in English, you will get some additional marks. Please, no abuse, okay? Don't start sending me emails, oh, I miss you so much, I would like to meet you every day, maybe twice a week, and you just come to my office and say, hi, it's really hot, okay, so give me some marks, see you, bye. No, please don't make an abuse, because I'm quite busy, as you are. So, I'm sure that we can do this in a reasonable way, okay? No abuses, no spam, meiwaku mairu, okay? No spamming. So, now you have more ways to earn some additional marks. But please remember, it's 5 points in total, maximum. Okay? It's important, but okay, it's not so much. So don't worry too much about that. Okay? Now, we start with lecture number 3. As you know, in this lecture, we are talking about Japanese law, but in English. So, here is a website where you can find English translations of Japanese legislation. Because Japan is a civil law country, which means that the first thing you need to check is a law. It's a website prepared by the Japanese Ministry of Justice. Ooh, so cool. But the translations are not official, according to the website. Yes, there are also mistakes. So, it's good for practice maybe. Okay, you can check the Japanese provisions and the English translation. You can also go to the website of the Japanese Supreme Court to find English translations of Japanese Supreme Court Saiko Saibansho decisions. Not all of them, only the important ones. Again, unofficial translations. The website says, we do not bear any responsibility, menseki. Okay? If there is any mistake, don't blame us. So, this is the website of the Ministry of Justice. Maybe the Japanese students will think, oh no, it's all in English. Okay, forget about that. No, there is the magic button. If you see there, it says Nihongo. So you just need to click there and everything becomes clear. And you can do a law search, a dictionary search, a keyword in context search. So there are many ways for you to find what you're looking for. And this is the website of the Supreme Court of Japan. Magic button, Japanese Nihongo, always. And you can find some major Supreme Court decisions. So today, we are going to talk about the sources of law. In Japanese, hogen. Ho from horitsu, and gen, which means minamoto. I need a student to write that on the whiteboard, maybe there. Who would like to write hogen in Japanese? Yes, please. Could you? I think there is space somewhere.
Should I write it in the middle?
Yes, maybe that's better. Excellent, thank you very much. Could I also have your name? You may have a seat. Could you pass the microphone to me, please?
Chisaki.
Okay.
C-H-I.
Okay, and your surname, please?
My first name is C-H-I-S-A-K-I.
Okay.
Last name I-N-A-B-E-T-S-U.
Yes. Yes.
That's it.
Okay, thank you very much. So, thank you, Chisaki, for writing hogen. Sources of law. You can see that it's a letter-by-letter translation. Ho means law, gen means sources. Now, the first question is, what's hogen? This hogen, not the hogen, Kansai Ben or etc. Okay, this hogen. This hogen is the rules judges use. Who would like to read? So, if you have a look at today's material, you will see that we have 1, 2, 3 pages slides, and then 1, 2, 3, 4 pages of provisions. So this is the style of the material from today and on, because we are also going to use some basic provisions. Who would like to read Article 76, Paragraph 3 of the Constitution of Japan? Yes, please, could you pass the microphone? So, I know that you're very happy to have the opportunity to read the provision, etc. And I would like to have your name.
My name first or
Okay, let's think which is more important. It's more important for you to get the marks, so let's have your name first.
Okay, R-I-R-I.
Okay.
But call me Lily though. That's my
Okay.
first name. M-A-T-S-U-D-A. Matsuda.
Okay, why do they call you Lily?
Oh, that's my name, but like my legal name has to be Nomaji, so it's like alright.
Oh, I see. Okay. Yes, thank you. Yes, so could you please read Article 76, paragraph 3 of the Japanese Constitution?
All judges shall be independent in the exercise of their conscience and shall be bound only by this Constitution and the laws.
So, this provision is a provision of the Japanese Constitution, the highest of all the laws, the Lord of the laws, like we say the Lord of the Rings, okay? The Lord of the laws, the highest law. And it says, the judge is bound, 拘束される裁判官は only by this constitution and the laws. この憲法および法律にのみ。So, the judge is not bound by his 上司 superiors. Let's say that you are a district court. District court means 地方裁判所. District court judge. And you have a friend who works in high court, 高等裁判所. You go to have some drinks. And he tells you, oh, this case is so easy. You should decide this way. You can tell him no. That's okay. And if he tells you why, you use Article 76, paragraph 3. You tell him, I'm not bound by you. I'm bound only by the Constitution and the laws. Next question. What kinds of laws do we have? Two categories. Statutory law or written law, 成文法, and unwritten law, 不文法. Written law is easy to understand. Law which is written, that's all. Unwritten law, what's that? Well, some examples. Customary law, 慣習法, case law, 判例法. Let's talk a bit about 慣習法, customary law. It's unwritten. Who would like to read Article 3 of the Act on General Rules for Applications of laws? It was a bit long. You can find it on page 3. Who would like to? Okay, yes, thank you. Yes. Oh, no, we have a new volunteer, so could you pass the microphone?
Testing. Hello.
Hi. Hello. How are you?
Thank you.
Do you feel lucky today?
I'm kind of, yeah.
Oh, that's nice. It's a question Google asks you. Huh? If when you open Google, you always find, do you feel lucky or something? So I wanted to ask somebody once. It has no meaning, okay, don't worry. So, what's your name?
Pang, P-A-N-G.
P-A-N-G.
N-G.
And yours, is this your first name?
Last name.
Okay, and your first name, please?
Chiho, T-S-Z.
Okay.
Joe.
Okay, thank you. So, could you please read Article 3?
Customs which are not against public policy shall have the same effect as laws, to the extent that they are authorized by the provisions of laws and regulations, or they relate to matters not provided for in laws and regulations.
Wow! So, this act tells us that sometimes customs, 慣習, have the same effect, 同一の効力, as laws, 法律と. When they are not against public policy and when they are authorized by the law or relate to matters not provided in laws. That's what Article 3 says. So, I will show you an example of a case where they are authorized by the provisions of laws. In Japanese, 法令の規定により認められたもの。Who would like to read article 234 and 6, not 5. 4 paragraph 1 and 6. There. Yes, could you pass the microphone to her, please? Could you raise your hand higher? He's looking for you. He's looking for you. No. Here. She's here. So, what's your name?
Yuki Miyake.
Okay, Yuki Miyake. Oh, I remember. You are the first or second Yuki?
Second.
The second, okay. You can also be the first Yuki. Okay, no, you don't have to, okay. You can decide that later, okay. You can do some janken. And if you win, you're Yuki number 1. If she wins, she's Yuki number 1, okay. No, you don't have to do it, okay. Okay, so could you please read article 234, paragraph 1?
Article 2034. In order to construct a building, the building must be distanted to 50 centimeters or more away from the boundary line.
Excellent, thank you. So, this provision tells us that when you construct a building, you must keep a distance of 50 centimeters or more from the boundary line. This is better for both buildings. You can have some sunshine in your house, more air, less noise, etc. So, the question is, yes, but every time I go to Pontocho, not me, you, not you, you shouldn't, nobody, okay. So, every time somebody goes to Pontocho in Kyoto, we see all these old buildings, not 1 centimeter, 0 centimeters, each of them. So, is this illegal? So, could you now read Article 236, please?
Article 236. If there are customers that differ from the provisions of the preceding 2 articles, those customs shall prevail.
Excellent, thank you very much. So, it's quite difficult to say if there is a custom in Kyoto. We cannot say for sure. But I personally think that yes, there is. There is a custom which says no 50 centimeters. The houses can be connected to each other. Okay? So this, I would say, is not illegal, although there is a provision of Article 234, paragraph 1, because there is a custom which says that it's okay, and we have a provision, Article 236, which says that we will take into consideration customs. Okay? So this is an example, and it's quite a Japanese example and a Kyoto example. So next time you will go for a drink, if you are adults, if you are not 19 years old, next time you will go for a drink, alcohol, you can also think about Japanese legislation. Before saying cheers, you will say Article 3 of the Act on General Rules for Applications of Law, and also Articles 234, etc. of the Civil Code. Cheers. Okay? Please do that for me. Now, well, if you do that, you might lose some friends. But it's okay, you can see there are many people, you can have new friends. Okay? Don't worry. So, next. We will have a break in 7 minutes, okay? Please be patient. Now, we have provisions, 条文で provisions. We can divide them largely into mandatory provisions, 強行規定 and discretionary provisions, 任意規定. What's that? Who would like to read Article 732 of the Japanese Civil Code? Yes, please. Yes. Oh, maybe you shouldn't just give her the microphone. You should tell her, if you allow me to be Yuki number 1, then you can have the microphone. Okay, negotiation. No, you don't have to do that. Okay, she's already. Okay. So, I remember you from a question. You are Yuki Yoshida. Yes. Oh, you should applaud anyway. So, yes, could you please read the article?
Okay. Article 732. A person who has a spouse shall not enter into another marriage.
Thank you. So, this article tells us that if you are already married, you cannot get married twice. So, double marriage is prohibited. There are some countries where you can do that, especially Arabic countries. But in Japan, you cannot do that. So, let's say that you create a circle. In Kyoto University, there are many circles, I think, fencing or shooting or calligraphy, etc. You can create a circle against Article 732 of Civil Code. You can find friends who want to get married with many people. You can create a circle, and you can say, okay, the Civil Code says only one marriage, but we are against. We think that multiple marriage is better. So, you go to the city hall to register 3 marriages. You with 3 guys, or you with 3 women. The city hall tells you, I'm sorry, but we have Article 732. And you say, yes, we know, but it's okay. We all agree to have the same husband, the 4 of us. It's okay, we can sign, we can put our income, we agree, there is no problem. The answer will be the same. No, sorry, you can't do that. Why is that? Because it's a mandatory provision, which means that, simply said, you cannot change it. Even if you all agree, even if you make a contract, even if you sign, whatever you do, you cannot change it. So, the question is, yes, this is quite easy to understand. So, what kind of discretionary provisions, nikite, do we have? Who would like to read Article 614 of the Japanese Civil Code? Yes, please, could you pass the microphone? Hi. Alright, so, let me guess. We had Yuki 1, Yuki 2, you're Yuki 3.
No.
It's not my day. Anyway, so what's your name?
Ken.
Ken, okay. Should I say Ken number 1? Is there number 2 or?
Please call me number 1.
Okay, so Ken the champion. Okay. And what's your surname? Your family name?
Higashi.
Okay, thank you. So, could you please read Article 614?
Okay. Rent must be paid at the end of a month with respect to movables, buildings and land for residential purpose, and at the end of a year with respect to other land, provided, however, that with respect to anything with a harvest season, the rent must be paid without delay after the season.
Thank you very much. It was quite a long provision. So, This provision tells us that it says rent, 賃料. The thing we call yachin usually. Well, it's not only for ie, so the correct word is 賃料. The rent for buildings, so the rent for an apartment should be paid when at the end of the month. So, if you are renting an apartment, usually if you check the contract, it says you prepay your rent. You pay the rent of August at the end of July. So now you feel really happy and strong. Whoa, I will go back, I will call the landlord and I will tell him, you are such a bad guy. Civil code says at the end of the month and you make me prepay. I'm gonna take you to court. Can you do that? The answer is no. Why is that? Because it's a discretionary provision, which means that you can change it if you agree. When I say this, students ask me, okay, so why do they have this provision? What's the meaning? Well, when you go to a convenience store and you buy water, I guess you don't sign any contracts. You don't say, yes, the price will be 100 yen, you will give it to me right now, etc. Let's sign, date. No, you don't do that. So the question is, yes, but what happens if there is a problem with the water? The answer is, you use the discretionary provisions of the civil code. So they are a model which you can use, you can change, and most importantly, if there is no agreement, no details, this applies. So, last thing before the break. Toshiba, Hitachi, etc., very large companies, they buy and sell things. They have contracts of many pages. They don't use a civil code. But when we buy something, water, when you go to the cafeteria and you buy something, there is no contract, no written contract. So what happens if there is trouble? These rules apply. They are a basic model. 5 minutes break. If you have any questions, feel free to ask me. If you do that in English, you get some marks. If you do that in Japanese, we will have a pleasant conversation. That's a very good question. So I will explain that. Sometimes
英米法、それと、韓中法
If you agree, then it's okay. But if you then please. Okay, so we have the also period. Then you can. So let's continue with the second part. Matthew, he asked me an excellent question, as always. So he's not a question, it was most of a remark, but it was very important. So his remark was, yes, we have these houses in Kyoto, and you talked about the custom, but aren't there any, how to explain that? Local provisions, for example, a Kyoto City Ordinance, Jōrei, etc., which talk about this? The answer is, he's right. Yes, I didn't think about that. So, what happens? When the civil code applied, when the civil code was introduced many years ago, then there were no Jōrei, local ordinances. So my answer was that, yes, if I rephrase this, at least for buildings which exist from more than 100 years, there are many buildings in Kyoto, then when they existed like this, there were no local ordinances, so this was a custom as an exception, etc. Okay? So regarding new buildings, I have not checked it, but most probably yes, there is an ordinance, so you don't have to use the customs. It's a bit difficult, you don't have to understand this, okay? Now, but you have to understand the next question, a very good question by 3 or 4 students. This you need to understand. The question was, how do we know if a provision is mandatory or discretionary? Answer, we don't. Sometimes the law says this provision, you cannot change it. Sometimes. So then you know, oh, it's mandatory. Most of the times, it doesn't say anything. So, it depends on common understanding. Question, what is common understanding? Answer, well, you don't have to worry, because in the end, the courts will decide. So if some people say this provision is mandatory, and others say no, this provision is discretionary, it means that you have a certain case, a specific case, which means that it might go to the court. Well, then the judge will decide if it's mandatory or discretionary. Okay? But to resume, so you need to know that sometimes the law says this provision is mandatory, do not change it. Most of the times it does not. So it depends on the common understanding. Well, my answer was that yes, you can understand that Article 732 is a mandatory provision, because otherwise I would have 4 wives, you would have 10 husbands, and it would be a chaos. So you can understand it's mandatory. And you can understand that, well, if you change the time you pay your rent, it's not such a big issue, it's okay. It depends on you and the owner of the house, for example. Okay? So, let's continue. Article 76, paragraph 3. You remember the article. It says that judges, they are bound, 拘束される, only by constitution and laws. 憲法および法律. Only, not by the 上司, superiors, etc. Please be careful. If you talk to Japanese lawyers, they will tell you that the decisions of the Supreme Court, 最高裁判所の判決, are also binding, 拘束力を有する. And you will think, oh no, this is not written in Article 76, paragraph 3. But it's true. If the Supreme Court says this is black, then this is black for all the courts in Japan. But is that written anywhere? No. So why is this so? 2 main reasons. First, the Supreme Court said this color here is black. I think it's gray, for example. But the Supreme Court said it's black. There is a case in Tokyo District Court, Tokyo 地方裁判所. And the judge thinks, no, this is not black, this is gray. So, I will ignore the Supreme Court decision. I will say it's gray. Can I do that? Yes. Because Supreme Court decisions are not binding. 拘束力を有しない. So, congratulations. But the lawyer of the party who lost the case will go to the High Court, Tokyo 高等裁判所, Tokyo High Court. Let's say that the Tokyo High Court judge also thinks, no, this is not black, this is gray. So he says, forget about the Supreme Court decision. He writes a decision, this is gray. Yes, can he do that? Of course, he can. What will happen? The party who lost will go to the Supreme Court. And what will the Supreme Court say? I told you, this is black. So he loses. So what happens? 地方裁判所 District Court said gray, okay. 高等裁判所 High Court said gray, okay. So you paid your lawyer a lot of money and you go to Supreme Court and of course you lose because the Supreme Court does not change its decisions. So, if you are a good judge, what will you do? You will say, I think it's gray, but if I say it's gray, the other one, he will go to High Court. So most probably the High Court will say, no, it's black. So he will lose time and money. So I'm not going to do that. The Supreme Court said it's black, so I'm going to say it's black. So that's the first reason, to save time and money. Because if you go to the Supreme Court, anyway, you lose. So the judges follow the Supreme Court decisions. Second reason, in Greece, I was a lawyer for 1 year and some months. It was really funny. You go to the court and you wait outside the judge's room. They come out and you look at their faces. Oh, he looks hungry today. No, we need to move the court for another day. So you ask him, not today please. Can you move our case to another day? Because he's angry, so he will make a bad decision. If he looks happy, then you say today is the day. So you ask him to make a decision. This is not good. In Japan, they don't do that. In Japan, it does not depend on, theoretically, on which judge your case goes, to which judge your case goes. So, if you have a Supreme Court decision which said that this is black, you feel very secure. You know that even if you go to the Tokyo District Court, Osaka, Sapporo, Nagoya, wherever you go, the judge will say, oh, it's black. That's better for you. Because you know, you can predict the court decision. Otherwise, it depends on the judge, which is not good. Okay, so two basic reasons. So, please remember, the Constitution does not say that the Supreme Court decisions are binding, but they are. Two main reasons. Any questions? Sure? Okay. Now, exception, Leigai. I told you that the Supreme Court does not change its decisions. So if the Supreme Court says this is black, it will always say this is black. But here it says, unless there have been social changes which do not support anymore the rationale of a decision. 社会の変化. So if the society changes, then the Supreme Court might say, yes, I said that this is black, but maybe nowadays it's gray, for example. This is a very famous example. The students who were attending my lecture last year, second semester, jurisprudence, remember this. It has to do with he. You are Kyoto University students. Could you please read the kanjis? He, please raise your hand. Yes, the microphone to her, please. Excellent, thank you very much. So, you are Chisaki.
Yes.
Yes, thank you. Okay. So, this is Hi Chaku Shutsushi. As you can easily guess, 50% of the students, of non-Kyoto University students in other universities, read this Hi Teki Shutsushi, which is wrong. So, we have children born in wedlock, Chaku Shutsushi, and children born out of wedlock, Hi Chaku Shutsushi. What does that mean? If the parents are married and they have a child, it's a child born in wedlock. If the parents are not married and they have a child, it's a child born out of wedlock. Who would like to read Article 900, Item 4 of the Civil Code? Yes, time is money, so you can raise your hand and thank you. Yes, could you pass the microphone to her, please? So I guess your name is not Yuki.
Yes,
Okay, so what's your name?
Saho,
Okay. So, could I also have your family name?
Yamada.
Okay, yes. So could you please read Article 900, Item 4?
If there are two or more children, lineal ascendants or siblings, the share in the inheritance of each shall be divided equally, provided that the share in inheritance of a sibling who shares only one parent with the descendant shall be one half of the share in inheritance of a sibling who shares both parents.
Thank you. So, this provision is nowadays okay. But almost 2 years ago, it was not okay. As some of you might know, it was saying that if we have a child born out of wedlock, it gets half of the child born in wedlock. And the Supreme Court in 1995, and also in some cases before that, said, cool, that's okay. So you can understand that the lawyers were saying this is against equality. It's not equal, because both are children. But the Supreme Court was saying, hey, you, Chakushitsushi, you're lucky. You should get 0, but you're getting half. So you're very lucky. That was the way of thinking of the Supreme Court. In 2013, so sorry, it's not 2 years, it's longer, it's 4 years ago. The Supreme Court, anyway, in 2013, the Supreme Court said, this provision is unconstitutional. It violates the principle of equality. So you think, what happened with you, Supreme Court? And the Supreme Court says, I'm fine. The society changed. Nowadays, the society treats equally both children born out of wedlock and children born in wedlock. So I need you to remember that the Supreme Court, when it decides, usually does not change its decision. That's why all the courts follow the Supreme Court. However, if there is a change in the society, the Supreme Court might change its decision. And if in the future you want to become lawyers, this is very interesting. You can change the society by being lawyers. You will be lawyers. You will know that there is a provision of the Supreme Court, but you will go again to the court for another case. You will wait until the court will say, you're right, society has changed. Okay? Now, as you have seen, sometimes we have provisions which say something, but what they are saying is not clear. So we need interpretation. In Japanese, kaishaku. And as I told you, there is not only one correct answer. There are many correct answers. So it depends on how logic and appropriate your answer is. You need to persuade. Who would like to read Article 129 of the Penal Code? Keiho. Thank you. Yes, so you are Yosuke. Yes, would you pass the microphone to him?
One and two.
Let me check the provision. Okay. Only one, please.
Article 129. A person who, through negligence, endangers the passage of a train, tram, or vessel, or overturns or destroys a train or tram, or capsizes, sinks, or destroys a vessel, shall be punished by a fine or not more than 300,000 yen.
Thank you. So, I was having a student who was really rich. He had a lot of money. His parents were rich. So he told me after the lecture, "Oh, this is so interesting. So I can destroy trains and trams and ships and then just pay some money." So I was like, no, don't do that, because it will stay on your criminal record. Okay, it's not only an issue of money. It doesn't mean that, oh, I have this amount, so let's go and destroy some ships today, okay? No, you shouldn't do that. So, what happened in Japan many years ago, was that some young boys put a stone on the railway and a gasoline engine car was overturned. What's a gasoline engine car? Well, at that time, they had the trains like the in Thomas. You know, those trains. The trains that move with steam. So, a gasoline engine car looks the same, but moves with gasoline. What happened? They were caught. They were brought to the court, and the lawyer said, "Oh, you know, judge, if you read the provision, it says train, tram, or vessel. But my clients overturned a gasoline engine car, which is not a train, not a tram, not a vessel. So, they are innocent." So the question was, is a gasoline engine car a train? The answer the judge gave was yes, because otherwise people would be free to overturn gasoline engine cars. It would be a complete chaos. So you can understand that, yes, according to the reason why this provision exists, of course, gasoline engine cars are trains. Who would like to read Article 199 of the Penal Code? Yes, please. So, Lily. Yes.
A person who kills another shall be punished by the death penalty or imprisonment with work for life or for a definite term of not less than 5 years.
Thank you. So, Lily, this is a favorite provision of students. They like this provision. Ooh, homicide and death penalty, etc. So, many years ago, there was a young woman who got pregnant. She didn't want anyone to find out about that, so she kept it a secret. One day she felt that the baby is that she's gonna give birth in a few minutes, so she went to the toilet. She locked the door. The child partially got out of her body and she killed it at the same time. She was killing it anyway. So the baby died. Now, as I described you, she started killing it while it was getting out of her body. So, she was caught, she was brought in front of a court, and the public prosecutor, Ken Satsukan, said that it's a homicide, 199, because she killed a person. Her lawyer said, no, it's not 199, it's something else, some other provisions, which have not such a severe punishment. So the question was, is a baby which is in the process of getting born, so it's half outside of the mother's body, a person or not? The Supreme Court said yes. From the moment a baby, even partially, gets out of the mother's body, it's a person. So if you kill it, it's homicide. So you can see that provisions, they seem to be clear, but they are not. They need interpretation, kaishaku, which is done by the courts. Why did I explain that? Because, as you can easily understand, if this decision is a Supreme Court decision, like in these two cases, then we have unwritten law. So as you remember here, we have written law and unwritten law. And I told you that an example of unwritten law is case law. This is how case law functions. If you open the penal code, you only have Article 199. But you also need to combine it with the court decision, which says that a baby is a person from the moment part of its body comes out from the mother's body. So you can also think the other way around now. If the baby is in the mother's body, it's not a person. So you can guess that there are many cases where this is important. Because if it's a person, you can have homicide. If it's not a person, you have a different result. So, Japan has laws, civil code, penal code, and also court decisions are important. Combination. Now, people think that law is very uniform and heartless. It's not. Because as you have seen, the judges, they try to make things work with humanliness. So the judge felt that no, this baby, a part of it was out of the mother's body. It's a person, you should not kill it, for example. So, the provisions, they look uniform and heartless, but through interpretation, you can have a fair and more human result. This sounds good, but it's also dangerous. Why? If the judge is a strange guy, and he has a strange way of thinking, he will be thinking that I'm doing something really nice now, which might be also wrong. Further, legislation, Rippo, and justice, Shiho. You have learned that these two are separate. But if the judge can change through interpretation the provisions, maybe he is doing Rippo, maybe he is legislating, although he belongs to Shiho, to justice. So this needs to be done very carefully. Now, I know that you are tired. We are finishing in 5 minutes. Please go there. Uji, you should go there. I went there in 2010. Okay, I went there in 2010. It was when I first came to Kyoto like some of you. And I went to Uji and I met her. She's Murasaki Shikibu. Very beautiful. If you meet her, you will fall in love. I wanted to get married to her. She's not alive, I cannot. But a friend of mine who was with me, he was saying, no, if you get married with her, she will be Karaiskos Shikibu, which is not nice. So I told him, no, Murasaki Shikibu is not her real name. It's the name she uses when she writes, a pen name, okay? But this conversation was meaningless anyway. I cannot marry her, so. But you should go to Uji anyway. So, we'll finish in 5 minutes. There are some categories of written law. You don't need to remember them now. We will explain them later. But you need to read Article 98 of the Constitution. Who would like to do that, please? And time is money, so I would appreciate. Thank you. Yes. So, Chisaki. And Chisaki, congratulations. You reached the maximum for today. You are the first student to do that. There is a maximum, because otherwise only Chisaki and Lily will be reading provisions. So in order to allow other students, there is a maximum, okay? And you are the first student to read that.
This Constitution shall be the supreme law of the nation, and no law, ordinance, imperial rescript, or other act of government, or part thereof, contrary to the provisions hereof, shall have legal force or validity.
Thank you. Okay, so, yes, it's really hot today, so you need to drink some water before reading the provisions. Now, this provision tells us that the Constitution is the supreme law of the nation. It's the boss. So, all laws need to be in accordance with the Constitution. This is something you need to remember. And finally, law can be divided in substantive law, jittai ho, and procedural law, tetsuzuki ho. Substantive law tells us what rights and obligations we have. For example, let's say there is a rule of Kyoto University saying if you cheat during the exams, you fail that subject. Okay? That's substantive law. So what would the procedural law be? It will describe how this will be done, whom you will meet, which professor you will meet, which committee will interview you, who will decide about you failing the subject. So, for example, we will finish with this, don't worry, 3 minutes. Who would like to read Article 211 of the Penal Code? Yes, please. So, Yuki, could you pass the microphone to Yuki, please?
Only one? Excuse me, only one?
Yes, only one, please.
Okay. Article 211. A person who fails to exercise due care required in the pursuit of social activities and thereby causes the death or injury of another shall be punished by imprisonment with or without work for not more than 5 years or a fine of not more than 1 million yen.
Excellent, yes.
The same shall apply to a person who through gross negligence causes the death or injury of another.
Thank you. So, 1 minute and we finish. Y was driving his car carelessly and he hit X and caused him serious injuries. Substantive law, please correct that. Substantive law says what happens? What happens? Not more than 5 years or not more than 1 million yen. Procedural law, it will say how the investigation, sosa, will be done, how he will be prosecuted, sotsui, how the court will make a decision, and how, if he says, no, I don't want to go to court, you remember, how we will force him to go to court. So that's the division between substantive and procedural law. We will start from the previous slide next week. Don't worry, we will start with a short revision. Thank you very much for attending the lecture. If you have any questions, you're more than welcome. See you next week.